So in Minnesota, he had these 4 counts of murder. So why 4 counts of murder when he only actually killed 2 people and the other 2 victims survived? That's just a vagary of Minnesota law. So in Minnesota law, you commit a murder and you're subject to a certain penalty. If you attempt a murder, an inchoate crime, you're subject to the criminal conviction, but because it's an attempt, you're only subject to half the maximum sentence of the actually successfully committed murder. So we see here murder with respect to victim 1, murder with respect to victim 2, actually caused the death for both of those. Caused the death of victim 1, caused the death of victim 2. And then when we get to count 3, attempted to cause the death of victim 3. Up here, I wonder why I don't have my red pen. So here he attempted to cause the victim. It's only an attempt because the victim survived. The maximum sentence is half of 30 years. So that's how you know this is an attempted crime under Minnesota law and not the full second-degree murder. The other issue is, why is this not premeditated? Because obviously he premeditated. I mean, he was wearing a cop costume. He was wearing a mask. He had all their names. He'd been doing surveillance. And the answer is because they can always change this. So it's really not until the indictment that things are locked in hard for trial. So what they want to do here is they want to hit him with a charge that's going to be solid enough to keep him in jail on a high enough bond that he can't get out. But they are totally free to upgrade this to first-degree murder if they want to at this point. This is just the complaint. This is not the final indictment. Now, right. Of course, we know he's in federal court.
Yeah, and let me add to that because, and I'm not sure of the rules on Minnesota, all right? And different states have different requirements. But my understanding is, well, it could be, there's a little speculation, it could be that in order to charge the highest level of crime, being first-degree murder, they may require a grand jury indictment. And so you can a prosecutor in Florida can file what they call an information, which is a charging document to everything except first-degree murder punishable by death. So, and they could have, now some states require grand jury indictments for a broad swath of felonies. So they may have a different standard. So in order to get a quick charge on the person so they can't bond down, they file what they call an information in Florida. They sign the charging document, the complaint, and then, like what Andrew says, they've got 30 days or so to send it to the grand jury, present the evidence, and then upcharge it if required. There's another wrinkle here, but I'll let you comment on it. There's another wrinkle on why it might be that way too, but I'll comment on that if you have anything to say on that.
No, go ahead. That's all. It just reminds me, actually, when you mentioned the information, I had forgotten that. It's what they did with George Zimmerman, of course, is they charged him on a second-degree murder on an information, which is just like a one-page document, like typed document. And then one of the investigators, often just an investigator for the prosecutor's office, just signs it like it's true. And I know in the George Zimmerman case, it was full of lies and misrepresentations. And so they actually got him into court in trial on a second-degree murder charge and an information that was complete bullshit. But it's what never happens. What would seem just is you could complain about that and say, Your Honor, the only reason I'm here is they used an improper information, an information full of lies. And the judge would say, oh, yeah, okay, we'll let you go. But that never happens.
Another thing that I saw that resonated with me when I was reading some coverage of these homicides is that he evidently targeted 2 sets of people, right?
Yep.
And that the people that died were the second set of people. And
right.
He was confronted by police at the second set of people.
Correct.
Now, you and I know that there's all kinds of premeditation elements present in the fact patterns here. The fact that he fled shows culpability. The fact that he's wearing a mask shows premeditation. There's a lot of the list, if the list is legitimate, which I don't know, or a manifesto. All of those show pre-planning. However, the fact that the second set of people were the ones that were murdered, were killed as of today, also may generate, and then he fled. I'm not sure of exactly the fact pattern that occurred there. So it may also be that the facts don't support premeditation in that second encounter. But we don't know the facts. This is one thing that's hard. We're speculating, and I'm 95% sure, that we're going to have that, but you really don't know the facts unless you're on the inside. So we need to be careful. Oh, look, here you do have.
We have the facts as claimed by the Minnesota prosecutors. So of course we don't know if this is true. I just said prosecutors lied in the information against George Zimmerman, but this is how the prosecutors are presenting the facts. So complainants investigated the facts and circumstances, believes the following establishes probable cause. On June 14th, approximately 2:05 a.m., Champlain police officers responded to a shooting. The 911 caller reported that a masked person had come to their door and then shot their parents. Inside the residence, officers found 2 adults, male and female, who had been shot, referred to herein as victim 3 and victim 4. So this would be the state senator and his wife who survived. Victim 3 is a state legislator. That's the state senator, Hoffman. Video surveillance footage from the exterior of the residence showed a... What is this now? This is... Now I'm confused about who this is. Because this was the deaths were the second group, right?
Yeah, I think this is the murderers here.
Well, they don't even mention the first.
Well, why do we have a victim 3 and 4?
Oh, now we have officers 3:35 a.m. This is very... Okay, so I'll read it, and then we'll see if it makes sense to anybody. Video surveillance. Oh, video surveillance. So the cops are not seeing this. This is like from a Ring camera or a security camera. They're looking at the footage afterwards. Video surveillance footage from the exterior of the residence showed a Ford SUV with police-style lights parked in the driveway of the residence. It also showed a man, later identified as defendant Vance Luther Boelter, wearing a mask, a blue shirt, police-style tactical vest, with a badge and yellow-gripped gun. That's weird. That must be the taser. Approached the front door with a flashlight. Defendant knocked on the door, announced himself as a police officer before entering the house and shooting victims 3 and 4. And they were shot a lot. One was shot 9 times, the other one 8 times. It's a miracle they survived. The surveillance footage showed defendant flee the residence and enter the police-style vehicle. Victim 3 and 4 are currently alive and remain hospitalized. A short time later, the Brooklyn Park Police Department learned of the shooting in Champlain, so a different town. Because one of the victims is a state legislator, police proactively sent patrol officers to the home of another state legislator in Brooklyn Park. When officers arrived at approximately 3:35 a.m., they saw the Ford SUV with police-style lights and immediately saw a defendant, still dressed as a police officer, shoot an adult male, referred to herein as victim 2, through the open door of the home. Wow, I hadn't heard that, actually. Police exchanged gunfire with defendant, who fled inside the residence before escaping the area. Inside the residence, officers found 2 adults deceased from gunshot wounds, victim 2 and his wife, victim 1. Victim 1 is also a state legislator. That would be Representative Hortman, who had just voted to end free health care for African migrants in Minnesota. Officers searched defendant's vehicle, registered to him, well, that's a connection, and located at least 3 AK-47 assault rifles, a 9mm handgun, as well as a list of names and addresses of other public officials. Officers canvassed the surrounding area, located a ballistic vest, a disassembled 9mm firearm, that's weird, a mask, and a gold police-style badge. Defendant is a listed purchaser for at least 4 of the recovered firearms. Additionally, investigators spoke with a person familiar with defendant who positively identified him as the man on the Champlain residence surveillance footage. Because defendant has not been apprehended, he has now, of course, been apprehended, and this case has significant media attention. Your complaint requests this warrant be sealed, and obviously now it is unsealed.
Now, reading this, I'm going to back off my theory about not having sufficient basis for premeditation. There is sufficient. I think that the reason is because of the grand jury. I'm going to guess that it's a grand jury problem. So they've got 30 days. In Florida, it would be 30 days to charge through grand jury. And that's called an indictment. People wonder the difference. That's called what an indictment is, a grand jury charge. Whereas, and it's required, it's constitutionally required, although it's a pro forma exercise. The grand juries are generally rubber stamps for prosecutors.
Yeah, so for the most part, the grand jury only hears one side of the argument, one side of the story. They hear the prosecutor's side of the story. And as we all know from life experience, if you only hear one side of the story, it sounds pretty compelling, right? Because there's no counter narrative to put things in context. So,
But not to be too cynical, but as a old graying wizened old lawyer, I have seen prosecutors use grand juries when they don't want to indict. And
right.
so it's politically a harsh thing. So they say, well, we presented it, the grand jury refused to indict, So it can be used either way, but it's basically a puppet of the prosecutors.
Yeah. So that happened in the Michael Brown case in Ferguson, actually, where Michael Brown, hands up, don't shoot. Where the prosecutor in that case, he could have presented just the evidence consistent with an unlawful shooting by police, but he presented all the evidence, including all the confounding witness statements, the witnesses that were obviously lying, all the evidence in favor of the police officer, and the grand jury elected not to indict that police officer. That prosecutor had been the prosecutor in that district for like 38 years or something. He'd been there forever. His next election, George Soros put up a young black male lawyer to run against him, and he lost his seat. So that cost him his career, that decision to show the grand jury all the evidence and
Well,
end up with a
sometimes doing the
non-indictment.
right thing is not easy.
Yep. And it was the right thing. It would have been another railroaded cop going through these terrible political persecutions. Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.